Hello everyone, this week we're gonna deal with Article 3 of the European Convention on Human Rights, which is about the prohibition of torture and inhuman and degrading treatment. Now you see a general intro in the beginning of the slides, and I'm not going to go into details about the definition. I show you on the relevant slides in the very beginning clearly the elements of the notion as understood by the European Convention on Human Rights when it comes to torture. Now, my goal with this week's videos is to help you go through a couple of cases and a couple of issues related to two very important aspects when it comes to the application of Article 3, namely the topic of detention and detention conditions in detention facilities, prisons and police stations, and on the other hand, when it comes to ill treatment. So this video now is addressed to the topic of detention conditions, which you already heard about, like when I introduced you the pilot procedure of the European Court of Human Rights. Then you had the chance to deal a little bit with this issue in the framework of the discussion on the Varga and others versus Hungary case, which was a pilot procedure conducted related to detention conditions in prisons in Hungary. So you dealt with the physical condition aspect of detention conditions in that case, but I tried to make it very simple. So it was rather focused on overcrowding, but you must know that even in that case, it was not only the number of prisoners that was of concern, but also other aspects of physical conditions. And so these different aspects of physical conditions is all the time commonly assessed by the European Court. So when it comes to the finding of violation or the lack of violation of Article 3, it's always about the complex picture about under what physical conditions that very specific applicant detainee has been living or was living while detained in the given prison. So as you see on slide 6, I brought you some that's kind of summarizing slide about the fact that inhuman, degrading treatment and torture, all of those categories and violations of the convention have been found by the European Court in detention cases. And then if you go on to slide 7, you will see two cases for physical conditions. You'll find these cases that I put on the slides also in your reading, but I just wanted to help you go through the reading more easily and to really focus on the major aspects of detention conditions that are outlined on the slide. So physical conditions, you see these two cases, Kalashnikov versus Russia and Modarka versus Moldova. And I just wanted to show you these cases that both degrading and inhumane treatment have been found by the court based on physical conditions in detention facilities. In the first case, you see that it was a very long period while the applicant was detained in pre-trial detention, 5 years, and one of the most serious aspects and issue in this case was that detainees were rotating on the bed, so not everyone had his own bed, but basically 14 cellmates were put in the cell, which had the capacity of providing accommodation for 8 persons only. So they had to rotate and use the bed in different parts of the day, which is a very problematic practice. but also there was problem with hygienic conditions and poor ventilation, which resulted in all kinds of milder diseases of detainees. While in the case of Modarka versus Moldova, a huge difference, and that was a very significant part of the picture, that basically there was a lack of food. So there was no sufficient quantity and quality of food provided to the detainees. That's a very problematic practice when it comes to material conditions of detention. To provide sufficient food to detainees is essential to safeguard their physical and mental well-being. So obviously it was handled as a serious violation of the European Convention by the court. Now, you see here on the next slide, slide 8, an additional example for pilot proceedings related to detention facilities. That was conducted against Russia. It's the Ananev and others versus Russia, where you see that in that very specific case, there was a number given for the space to be provided in a cell to the detainees. It was a minimum of 3 square meters, but I need to tell you that it's not a fixed number. There is no such objective criteria set by the court that it would be 3 or 4 square meters that should be provided, but it differs because the size of the cell is always considered and assessed also in light of the other parts or other aspects of physical conditions. So as you see here, additional considerations should be taken into account by the court, like how long the detainee was held in that very given cell, how many hours did he or she spend in that given cell, the detainee had the possibility to have like open air activities, or did he work, or did he spend like 23.5 hours per day in that cell, because obviously it will be then assessed in a more severe way or stricter way. And so how was the physical condition of the detainee, like the health of the detainee himself or herself? Were there any negative consequences on the health that can be proven? And so on. All these kind of factors are assessed by the court when it comes to physical conditions. Now, let's go on to slide 9, search. Search in the case of detainees can be absolutely legitimate and necessary. For example, if a detainee is brought outside the prison for work, then it's a regular and acceptable practice. Then when he comes back, then he should be searched to check out whether there are any prohibited objects that were brought in the prison. So it's just normal. But obviously, as you learn from the general human rights stats, there should be a legitimate aim behind this restrictive measure. And so you see here two example, a Polish case, Iwancuk versus Poland, and Van der Ven versus the Netherlands. Now, in both of their cases, these cases, there was a search conducted by the prison staff, which was applied against and complained against by the applicants at the European Court. And you see that in the Dutch case, it was handled a little bit stricter by the court. The court found not only degrading treatment, but inhumane and degrading treatment, which means that the European Court emphasizes that it's a more severe violation of Article 3. What was the difference? The difference was that in the Polish case, it was like a one occasion practice and measure. Basically, they did not let the applicant vote at the national elections, which obviously bring up another concern with regard to the violation of human rights enshrined in the European Convention. And then so the guards were kind of pressuring the detainee that if the detainee does not strip naked, and then in the presence of more guards, he would be body searched. If he does not contribute to that or allows that, then he's not allowed to vote at the national elections. And so he refused the detainee, but it was like obvious that the whole practice, the whole pressure was about humiliating him, and he could prove that, and so it was qualified as degrading treatment by the court. As opposed to this case, in the Dutch case, it was a regular practice. On a weekly basis, the applicant was stripped naked and searched, even for 3 years. And this practice was upheld even if it was a high security prison, high security institution, which means that basically there was no need. So strict measures, security measures were imposed on the detainees that there was basically no need for strip and search. And so it was crystal clear that the sole purpose of this practice was humiliating the prisoner. And so the Netherlands was found responsible for violating Article 3, and the situation and practice was qualified as inhumane and degrading treatment. Now, similarly to search, solitary confinement can be imposed on detainees in a legal and justifiable way as well. It might be that it's needed in order to safeguard the health or even life of other detainees, or the detainee himself who is put in solitary confinement. But it might easily be that solitary confinement is imposed on the detainee as a sanction. And of course, there are rules to be applied for this kind of sanction because it's a very serious sanction. Solitary confinement itself has very negative consequences on the physical and mental well-being of the detainees. But if it's applied to a limited time and like with all other kinds of safeguards, given, then it's acceptable. Now, in extreme cases, when it's like about very serious crimes like terrorism, this measure can be applied for a longer term as well. As you see these two cases, they have similarities and differences. Ilascu and others versus Moldova and Russia, and Ramirez Sanchez versus France. In both cases, we have terrorism as the crime of the suspected crime or the crime that the applicant was convicted for, and they were held in solitary confinement, both of them for 8 years. Now, if we compare that, one significant difference is that basically Ilascu and his co-applicants were detained for political reasons. He was a politician, and so Russian-backed authorities detained him and his co-applicants, and so it's a huge difference. While Ramirez Sanchez, or the nickname was Carlos the Jackal, he was a real terrorist who was responsible for terrorist attacks leading to many deaths and casualties in the 70s for the Palestinian cause. And so in the first case, you see that there were all kinds of major problems with detention. There was no access to the outside world, no visits, not even by lawyers. There was lack of heating when it was cold. There was lack of ventilation all the time. Deprivation of food was applied as a sanction. And there was a very severe impact that resulted by this measure on the applicant. And so based on that, this practice was qualified by the court as torture. So the most extreme form, the most severe form of the violation of Article 3. As opposed to that, in the case of Ramirez Sanchez, even if he was detained in solitary confinement for 8 years, just like Ilascu and co-applicants, the court found no violation of Article 3. What's the reason of that? Because in the case of Ramirez Sanchez, all kinds of possibilities were provided to the applicant to spend time in a sensible way. So there was access to television, newspapers, journals, regular visits were paid to the applicant by the lawyer, by a priest, by relatives. He was in good state of health and so on. And the only one concern of the court was related to that. There was a lack of judicial review of the solitary confinement. Obviously, it should be regularly reviewed whether the legitimate aim to keep the detainee in solitary confinement is still present. It should be reviewed by judges, not only the prison staff. But still, the court found no violation of the European Convention. Now, if we go on to slide 11 and medical treatment, just briefly, I need to emphasize that it does not mean that like prisons are obliged to provide like the highest quality level of medical treatment to prisoners. No, prisons are expected to provide like a regular minimum medical treatment that is provided in civilian hospitals and medical services. And so what is for sure when it comes to chronic diseases, then regular medical treatment and the necessary medication should be provided to the detainees. So it's not enough to provide medical treatment on one occasion and that's it. As you see in the Kudobin versus Russia case, so the applicant had very chronic diseases, epilepsy, mental diseases, HIV, and he was not provided regular medical review. He was not provided medication, and so it was found inhuman treatment by the court. Keenan versus UK case is a very particular one. And here the court found inhuman and degrading treatment, so qualified in a more stricter way by the court because basically the applicant died. What is the reason that not Article 2 was applied, right to life, if the applicant died? Because basically the court found that the authorities, when they put for an additional 28 days in detention the applicant before release, the court found that the authorities did not know that the applicant was schizophrenic and had serious mental disease and prone to suicide. And so they could not expect that suicide will be committed in solitary confinement by the detainee. But it's true that they did not provide psychiatric assistance, even if they knew that there is a fragility in the mental state of the detainee, and because of that, the UK was found to have violated Article 3 through inhuman and degrading treatment. So I hope that these cases, these examples, demonstrated to you the most important aspects of detention conditions when it comes to the application of Article 3. And we go on in the next video with other examples when it comes to the treatment and application of Article 3. Let me know if you have any questions.